The Homeland Security recently issued a new public charge rule that our customers have been asking about, so we wanted to briefly go over this. A public charge, as defined by the USCIS, is a person who is likely to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalization for long-term care at government expense. In other words, a public charge is a person who cannot support themselves financially and depends on certain welfare benefits. People who are likely to become a public charge are not admissible to the U.S. and are not eligible to receive a permanent resident card. This has been the rule for so many years. There are two major factors that concern our customers about this new rule. The first major factor is the use of certain public benefits by the applicant. Now, any non-immigrant alien who is intending to adjust status and has used any public benefits in the USA, they would be denied a visa. The language of the new rule specifically mentions the alien and not the U.S. citizen sponsor. In this case, the public benefits must have been received directly by the applicant for the applicant's own benefit. The new rule, which goes into effect on October 15, 2019, mentions the following benefits considered: any federal, state, local, tribal cash assistance for income maintenance, supplemental security income or SSI, temporary assistance for needy families, TANF, federal, state, or local cash benefit programs for income maintenance, often called general assistance in the state context, but which may exist under other names, Supplemental Nutrition Assistance Program or SNAP, or formerly called food stamps, Section 8 Housing Assistance under the Housing Choice Voucher Program, Section 8 Project-Based Rental Assistance, including moderate rehabilitation, public housing under Section 9 of the Housing Act of 1937, federally funded Medicaid with certain exclusions. So in general, it's fairly uncommon for a non-immigrant to receive any of these benefits.
So the second major factor related to this new rule is the poverty threshold of the sponsor's income. The sponsor is required to meet at least 125% of the poverty guidelines. This has been the rule for some time and is not changing per se. But what is changing is that the Department of State is setting the bar higher, explicitly stating that if your income is below 250% of the poverty guideline, your case is going to receive more scrutiny. That means they're going to review it and they're going to look at the supporting documents, and they want to ensure that you meet this guideline. And just to give you an example of what 250% of the guideline is, for a family of four, you're looking at approximately $64,374. So that's considerably higher than it was before. Now, it's kind of a gray area on how they're going to scrutinize this because, as many of you probably know, income and supporting documents are very subjective, meaning that it's going to come down to the discretion of the officer reviewing the case. So you're going to need to provide more documents. They're going to look at your finances, and we anticipate that we're going to see quite a few more RFEs, that's requests for evidence letters. We also anticipate we're probably going to see more denials. So there's going to be a lot more information on this to come after the rule goes into effect. But what we can recommend right now is to submit your application or your petition as soon as possible. If you'd like to get started immediately, give us a call and we'll help you out with this, because we do expect this to have a major impact.
Okay, next question is from Michael and Heidi. Do the new October 15 income rules of 250% apply at the time of filing the affidavit of support or at the time of filing of the 130? I have a pending CR1, 130 waiting for NO82. So the new rule will take effect on October 15, and that would be all petitions that will be filed at October 15 onwards. So if you have already pending a CR1, it doesn't affect your petition, because it doesn't have a retroactive effect. It will only affect petitions filed on October 1 onwards. That's what I.
And the other concern here is, or the other question that we may not know about yet, is whether or not this is going to affect the affidavit of support filed with the consulate that's overseas. Right now, what we're looking at is adjustment of status packages filed with the USCIS. It's unclear at this moment how this is going to impact the I-130s and the I-485s or the I-864s, which is the affidavit of support filed with the National Visa Center, which in turn sends it over to the embassy. But for your case, you should be fine. You've already filed and you're well ahead of the game. But as I stated earlier, for anyone else out there, you really should apply as soon as possible, because once this goes into effect, we anticipate quite a few more RFEs, requests for evidence, as well as denials. We're not sure if they're going to request that you get a joint sponsor, or we're not exactly sure if you can use assets. So there's a lot of unanswered questions regarding this new rule that goes into effect in October.
Will the K-1 visa income requirements going up in October 15, or is it just adjustment of status, 250%? Are you able to get a co-sponsor once in the United States? Oh, another 250% question. The income requirements.
Just to let everyone know out there, the income requirements are not going up, okay? If you'll look at the HHS poverty guidelines, the income requirements have stayed the same. Yeah. Okay, the only thing that came out with the new rule from the U.S. Department of State is stating that they are looking at incomes in between 125% and 250%. Those are the ones they're going to scrutinize more. Okay, so if your income is over 250%, say it's over $65,000, you're going to fly through with no issues, okay? But if you're below that 250% level, they're going to scrutinize it more. So they're going to look for more evidence. They're going to look at several factors. They're going to look at your age, your health, your employment, okay? Whether you're retired, whether you're receiving Social Security. They look at a lot of different factors. The USCIS actually has a document out there that lists all the factors that they look at. And they take all this into consideration, and they just want to ensure that the beneficiary is not going to collect means-tested benefits, okay? Food stamps, welfare, things like that. But if you are below that 250% income level, in some countries, at some embassies, you may use a joint sponsor to meet these income requirements. But if you're from the Philippines, not so much. They do not accept joint sponsors for the K-1 fiancé visa. They do for the spousal visa, but not for the fiancé visa. So again, we don't have all the answers on this new rule yet. There's a lot more information that's going to come out, especially once we start receiving RFEs and denials. Because usually in those RFE letters, the request for evidence letters, they'll tell you exactly what they're looking for. They'll tell you you need a joint sponsor, or we need to see your IRS tax transcripts from the previous year or the last 3 years. So what we expect or anticipate is that they're going to be looking for more. So I can tell you, usually to prove your income, they want to see your last year's tax returns, and they want to see your W-2s. And we also recommend providing 3 to 6 months of your pay statements. If you're a business owner or independent contractor, a lot of times you're going to want to provide 6 months of bank statements, including all your tax schedules. So again, with this 250% rule, there's a lot more to come on that, but right now just know that the income requirements have not gone up. It's just this is giving them some more leeway, I think, to scrutinize petitions more. So yeah, more to come.
If you found this video useful, it would mean a lot to us if you could hit the like button and comment below to let us know what you think. You can also ask your own immigration questions in the comments below. If you want to make sure not to miss any of our future videos, we invite you to subscribe here on YouTube and be sure to click the notification icon so you can be alerted whenever we publish a new video. Also, don't forget to follow us on Facebook, where you can watch our regular immigration Q&A live streams.